is hearing arguments today in a case that could completely reshape the internet.
Gonzalez versus Google addresses whether or not tech companies should be held legally liable for harmful content promoted by their algorithms.
The Supreme Court is set to hear two cases this week that could potentially shape the future of internet content and how it's moderated. At stake is whether social media and tech companies can be held liable for certain recommendations to their users.
So let's talk about the Supreme Court case, Gonzalez v. Google. The law today protects social media companies from lawsuits based on content that people post to the websites. This is known as the publisher-distributor distinction. See, if you're a publisher, that means you're a company that creates things like newspapers or magazines to be sold. Examples would be the New York Times, Washington Post, or the New Yorker magazine. Distributors, on the other hand, are the newsstands and bookstores that sell newspapers and magazines to the public. They are distributors of the content. So let's say someone goes into a newsstand looking for fishing magazines. Well, the newsstand, they manipulate the search. They put their more popular products in front at eye level so people can see them, making them easier to find, while less popular products they put in the back where it's a little harder to find. They also recommend content. If you go ask the person working at the newsstand, hey, what are some good fishing magazines? They're going to say, hey, here are a couple, or this is what most people are reading. And the newsstand also moderates content. They refuse to sell some newspapers while definitely selling and promoting others. Now, if a particular newspaper or magazine had defamatory content in it, the newsstand that's selling that content is not legally responsible for the content in the newspaper. They just sell it. Now, this takes us to federal law and Section 230, which essentially makes social media companies into digital newsstands. Instead of selling newspapers, it's videos on YouTube, pictures on Instagram, posts on Facebook. They're all treated the same. A company distributing this third-party content is not liable for what's in the content unless they have actual knowledge of what's in it. Now, that makes sense because there's no way that a newsstand owner or a bookstore owner can read everything in their store before they're selling it. Now, like the newsstand owner and the bookstore owner, YouTube is in the same position. YouTube has 30,000 hours of video uploaded to its site every hour. There's no way that they can review all that content to see if there's any defamatory content within it. Now, with this simple understanding of how it works and why it works, that brings us to the case Gonzalez versus Google LLC.
Noemi Gonzalez, the young American victim in the Paris attacks, was remembered in a vigil at California State University, Long Beach, where she was a student studying abroad. Her boyfriend of nearly 4 years, Tim Mraz, spoke to students.
My condolences to her family and everyone else in Paris, to all the other students. Thank you again for being here. She'll always be here. She'll always be in my heart. I love you, babe.
Noemi Gonzalez, a U.S. citizen, was killed by a terrorist attack in Paris, France in 2015, one of several terrorist attacks that occurred that day. The day afterwards, the foreign terrorist organization ISIS claimed responsibility by issuing a written statement and releasing a YouTube video. Gonzalez's father filed a lawsuit against Google, Twitter, and Facebook, claiming, among other things, that Google aided and abetted international terrorism by allowing ISIS to use its platform, specifically YouTube, to, quote, recruit members, plan terrorist attacks, issue terrorist threats, instill fear, and intimidate civilian populations. More specifically, though, the complaint alleges that because Google uses a computer algorithm to suggest content to users based on their viewing history, that action assists ISIS in spreading its terrorist message. Now, the Gonzalez family claimed that all three platforms were also liable for aiding and abetting international terrorism by failing to take meaningful or aggressive actions to prevent terrorists from using their services. Now, even though the companies didn't play an active role in the specific act of terrorism, the Gonzalez family believes that the companies actually injured Gonzalez by promoting this ISIS content. Now, the district court granted Google's motion to dismiss the Gonzalez complaint based on Section 230, and the U.S. Court of Appeals in the Ninth Circuit also affirmed. So the legal question the Supreme Court is going to answer is, does Section 230C1 of the Communications Decency Act, which we know as Section 230, does it immunize interactive computer services when they make targeted recommendations of information provided by third-party content providers? So let's look at Section 230. Here it is. 47 U.S.C. Code Section 230, subsection C1. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Now let's break this down. The plaintiffs in this case are claiming that by recommending content to users through the algorithm is essentially equal to publishing content as a content creator. Let's go back to our newsstand example. Let's say a frequent customer who likes motorcycle magazines comes into the newsstand and asks the owner, hey, are there any particular good motorcycle magazines that are out now? And the owner then suggests magazines in the motorcycle section and then tells this patron that, hey, here's the more popular one, cycles and bikes or something like that. That recommendation would now make the newsstand owner legally liable for all the content within that magazine. Now, that's essentially what the plaintiff is asking the court to find, that recommending content is the same as publishing content. So if the Supreme Court takes that view, that recommending content is the same as publishing content, then essentially what Google is doing is aiding and abetting in terrorism. But a staunch critic of Section 230 is Justice Clarence Thomas. And he seemingly came to Google's defense, shocking most people who are watching the court case. And Justice Thomas doesn't buy the whole recommending content argument is the same as publishing content, or recommending or suggesting content leads to aiding and abetting terroristic acts. Here's what he had to say.
What if the YouTube, instead of automatically providing this list, which is hard, it's hard for me because I don't see this as, I see these as suggestions and not really recommendations because they don't really comment on them. But what if you had to click on something like, for more like this, click here? Would that also be, as far as you're concerned, aiding and abetting?
If, in terms of aiding and abetting, if someone comes to me and says, what's al-Baghdadi's phone number, I'd like to call him, and I give him the phone number, I'm aiding and abetting, even if I don't say, and I hope you'll join ISIS. Whether we label it a recommendation or not, on our view, is not the issue here. We tried to say that in our brief.
I mean, if you call information and ask for al-Baghdadi's number and they give it to you, I don't see how that's aiding and abetting. And I don't understand how a neutral suggestion about something that you've expressed an interest in is aiding and abetting.
Now, on the liberal side of the court, it seems like the justices believe that Google should be held liable for something in this case, but don't really explain what exactly they should do. Here's Justice Kagan explaining their quandary.
Every other industry has to internalize the costs of its conduct. Why is it that the tech industry gets a pass? A little bit unclear. On the other hand, I mean, we're a court. We really don't know about these things. You know, these are not like the 9 greatest experts on the internet. And I don't have to accept all Ms. Blatt's "the sky is falling" stuff to accept something about, boy, there is a lot of uncertainty about going the way you would have us go, in part just because of the difficulty of drawing lines in this area. And just because of the fact that once we go with you, all of a sudden, we're finding that Google isn't protected. And maybe Congress should want that system. But isn't that something for Congress to do, not the court?
Now, just to be clear, the Supreme Court has ruled on an issue like this in the past, before the internet became a thing. In a case called Smith v. California, you guys should look this up, it's 1959, the Supreme Court unanimously held that an LA bookstore owner could not be held criminally liable for selling a pulp novel called Sweeter Than Life. It's by Mark Tryon. And this was because the court reasoned that the bookstore owner didn't have actual knowledge of what was in the book. See, the court reasoned that holding a bookstore liable in this way would require that all the workers in the bookstore would have to read every single book before selling it. This was impossible and impractical based on the amount of content bookstores and newsstands sell. Now, this is as true today for YouTube, as an example, who has 30,000 hours of newly updated content per hour, making it impossible for YouTube, just like the bookstores, to watch every video, to police every single piece of content. So a lot of people are claiming doom and gloom if the plaintiff wins. But what really happens if the plaintiff wins this case? Well, we go back to the internet before algorithms suggested content. See, your homepage on YouTube will likely be just a search bar, like the homepage on Google today. You can bookmark content you like by subscribing or hitting the bell. You can do that now if you want, because subscribe, hit the bell. It was a nice little transition for it. But anyway, nothing would be suggested to you. You would have to essentially find it yourself. Now, the effect on content creators is going to be massive. See, creators who have huge followings will continue to excel, but new and upcoming creators trying to make it will be horribly limited. See, instead of your content being suggested to new people by an algorithm, those new people would now need to find you. But how can they find you if they don't know you exist? This would make it very unlikely that content from small creators would be able to either be found at all, and making it less likely for that content to go viral. So now you know the facts, the law, and the policy behind it. With that said, who do you think should win? Should suggestions by social media companies be treated as publishing content, making those social media companies liable for those suggestions? So let me know how you came out in the comment section. And how do you think the court's actually going to rule? Do you think the conservatives like Justice Thomas are going to uphold Section 230 as it is now, when Thomas has been looking for an opportunity to scale back some of these protections? Or do you think the liberals are going to find a way to still hold Google accountable, but keeping the meat and potatoes of Section 230 in place? Let me know in the comment section what you think is going to happen. My name is Nate the Lawyer, and I'll see you next time. Peace.